Welcome back to Left Anchor. I'm Alexei the Greek.
And I'm Ryan Cooper. We're welcoming to the show today Professor Mark Tushnet. Am I pronouncing that correctly?
Sure.
Close enough. Good enough for government work. Who is the William Nelson Cromwell Professor of Law Emeritus at Harvard Law and has just written a book called Who Am I to Judge? Judicial Craft versus Constitutional Theory. And is that, it's not out yet, if I'm not mistaken?
Soon. Very soon.
Actually, the official publication date was yesterday.
Oh, there we go.
There it is.
February 25th, whenever you broadcast this. It's out.
Yes, it's out. Fresh.
Timely.
Hot off the stands.
Yeah.
Excellent.
Get your freshly pressed copies, from your latest newsboy. Run down to the corner and find one. Yeah, and so your book, Professor, you're sort of you're talking about kind of the roots of how like the law works in the United States, and you make an argument about shall we say like judicial theorizing versus judicial craft, and maybe you can sort of lay out at the beginning, sort of your vision of what judicial theorizing is so that we can have a good sort of conception of the status quo and what you're arguing against it.
Sure. So in recent confirmation hearings, Republican senators in particular have asked nominees what their theory of interpretation is. How do they think about interpreting the Constitution? And the answer they're looking for is originalism, but in general, originalism is theoretical in the sense that it gives purports to give guidance on resolving a whole range of constitutional issues pursuant to a relatively limited number of presuppositions or axioms, if you want to call them that. So for originalism, the theory is you interpret the Constitution these days in light of or with reference to the understanding of the constitutional terms held by the public in at the time the constitutional provision was adopted. Okay, so that's a theory. It's crisp, it's confined, it's relatively easy to describe, in contrast to what I call judicial craft, which involves working with a whole set of materials in the way that lawyers generally work with materials.
Right. And you also note that there's a kind of cosmic theorizing, such as, originalism, where you have a kind of overarching understanding of how to interpret the Constitution that you apply no matter what kind of case is before the court. And you contrast that a little bit with kind of local theorizing that is much more specific to the precedent that is, within a particular domain, whether it's patent law or a different type of law. Can you describe why that matters to understand this?
Sure. So the term cosmic, it comes from the conservative Judge J. Harvey Wilkinson. And he's against cosmic theorizing too. He thinks it doesn't capture the way he as a judge approaches issues. But cosmic theorizing is, about everything. It's about the universe. So it's about the way people talk about it in terms of originalism. It's about how words are used in legal contexts. Okay. So that's everything. I mean, that's the law. There are sort of, as you put it, local theories. The best kinds of examples are, I think, highly technical areas, like, as you mentioned, patent law and tax law. And patent lawyers and tax lawyers see their subject matter as involving an array of complicated issues involving the underlying substance, what the tax law is, and the institutions that create it and administer it. And they have a sense of how those institutions operate. I'm not sure they would call what they have as a local theory. They have a grasp of what the specific topic, how that specific topic works itself out in the law.
Right. But I would guess in any one of those quote unquote local theories, there's less likely to have the strange correlation that we have with originalism, where almost all of the conservative judges prefer it and conservative politicians prefer it. And there's a strange kind of ideological, political appropriation of that cosmic theory that tends to give a certain kind of signal to voters in a certain way. I would assume. I don't know. Maybe I'm wrong about that. But what do you think?
I would say that you've described what I call in the book judicial originalism. That is originalism as practiced by today's judges. Right. And there is clearly a correlation between adherence to, at least verbal adherence to originalism.
Right. Rather than practice,
conservatism. I'll say a little more about that later, probably. Yeah. In contrast, there's what I call in the book academic originalism, and that's an academic enterprise. And there are people who are political liberals who engage in what they describe as originalist inquiries. It's not surprising that when liberals do it, they tend to come out with liberal understandings of what the historical materials produce. But it's, in my view, sort of more respectable because it's more qualified and more nuanced than what you get from the judges.
For us sort of, non-lawyers, maybe you could drill down a little bit more into this notion of judicial craft, because I was, I guess, a little bit surprised perhaps to learn, from your book that constitutional theories in the way that you're talking about, which strikes me as sort of similar to fundamentalist Christianity, that they're relatively recent, that this wasn't really a thing until sort of the latter part of the 20th century. And, a more nuanced and sort of holistic and wide ranging approach that would draw on many different sources was much more common sort of before this era of sort of hegemonic schools of, quote unquote theory. So can you talk about, sort of the core argument of your book that a good judge is one who has judicial craft?
Yeah. So your description is right. I have a chapter in the book that looks at a number of decisions issued in the 1930s. It's a period I know because I wrote this enormous book about it that nobody read properly. Nobody reads it. It's just used just for libraries to have on their shelves. But I know the cases from that period a lot. And when you look at what the judges do in that period, they do things that sort of sound like some things that we call theory today, but they pull from a whole bunch of sources. They analogize to older cases. That's how they use precedents. They think about the implications of their rulings for organizing a government, and all the kinds of things that a lawyer sitting in her office would do when a client presents a problem to her. Lawyers don't theorize. They try to figure out what the whole range of legal materials points to. The rise of theory was a historical phenomenon. It occurred in the end of the 20th century. Mostly it occurred because Republicans were trying to figure out a way to describe their opposition to the liberal Warren Court in terms other than their liberals were conservatives. And so they said, well, we have this theory, originalism. They were just implementing their personal preferences.
Yes, which was a clever piece of propaganda and polemic, because it tied partisan ideology to a question of legitimacy and to whether you're a true American and you respect our system or not, and made the allegiance to originalism or not a kind of bifurcating path where you were an activist judge if you don't use it, and if you did, then you were a true American who understood the Constitution.
Well, right. I mean, it was part of a larger scale, political program to oppose the Warren Court and so on. I do want to note that in partial response to Republican conservative promoting of originalism, liberals had two kinds of responses. One was to say originalism doesn't make any sense. I contributed to that literature, 40 years ago. But the other was to say we have a different theory, a better theory. And we think the way the Constitution should be interpreted should be basically to promote democratic decision making.
Yeah, tell us a bit about why you think that is not the right approach as a response.
The basic problem is there's too much disagreement about what democratic decision making is. And so the democracy reinforcing ideas turn out to be just as manipulable as originalist ideas are. And so, although remember, we're starting out, conservatives say you need a theory, liberals say we have a theory, it's originalism, liberals say that's a terrible theory, we have an alternative theory, it's democracy reinforcing, conservatives say that's a terrible theory. And they're both right.
Is it a rhetorical problem in the sense that if you don't claim you have this overarching theory, you can't be so easily defeated when holes are poked in it, something like that? Like, because your writing on Judicial Craft certainly doesn't prohibit, or when you point to great justices, you don't say they never theorize at all. It's just that they don't have a kind of, they don't go top down with the theory first. They're kind of following a good lawyer's inductive reasoning process and going bottom up and figuring out in places where theory might be useful, something like that. Is that fair?
Yeah, no, that's right. That's I try to capture that by referring to all the materials available to a lawyer, which include proto theories or hints at theory, but also something that theory more or less excludes, which is thinking about the implications of this ruling for the way our government is organized
and how people are affected,
how people are affected by it. I mean, theory sort of screens that out as an explicit consideration. Now, of course, you have, the ultimate grounding of the theory is if we adopt it, we're going to be better off than if we do something else. But you don't do that when you're theorizing or when you're applying a theory. You don't do that with respect to the specific cases. And good lawyers do that.
And to be fair, the Scalias of the world certainly were inconsistent, as you point out, in their application of their theory or in their formulation of originalism. I'm thinking especially of like Oregon v. Smith, the free exercise clause case with the use of peyote as a violation of the general, criminal prohibition against drug use. And Scalia came up with like hybrid rights and just kind of a million little dance moves in order to get to the result he wanted. And yet he likes to pretend, or he, God rest his soul, liked to pretend that his was a more kind of confining approach that limited him epistemologically, right?
Yeah, so there are a couple of things to say here. One specifically about Justice Scalia and one about originalism more generally. With respect to Justice Scalia, he actually had two big ideas, and they were in some tension with each other. One was original understanding, and the other was judges need to follow rules. They shouldn't have complicated standards, or they should have simple rules, actually. They shouldn't have rules that have 5 parts to them. And sometimes when you do the original meaning stuff. It turns out that it was complicated. And so, okay, so that's a particular issue with respect to Justice Scalia. But the other observation is that originalism comes in a number of varieties or flavors. And because it does, people who say they're originalists, honestly say they're originalists, can pick and choose which variety or flavor they want to follow in the case at hand, so as to produce the result they want.
To give the audience a few examples, there's like originalist intent, which might have to do with the intent of the legislators at the time or the intent of those who ratified the Constitution. Then there's original meaning, which has to do with like publicly accessible understandings of the term that doesn't have to do specifically with the founders or the legislators, but just at the time generally. And so there's a lot of different moves that one can make within originalism, right?
Yeah. So the most common alternatives are what in the academy we call original expected applications. So you look at the Constitution and you say, look, given the terms of the Constitution, they couldn't possibly have expected that the death penalty would be unconstitutional. Or if you look at what they said about schools in 1868, they didn't expect that the 14th Amendment was going to prohibit racially segregated schools. That's, they knew what they were doing. They had expectations about what would happen, and we should follow them. Okay.
And to tease that out just real quick for people, the reason they say that death penalty couldn't be cruel and unusual is because it was happening at the time of the ratification and of the Eighth Amendment. It was something that was in practice. So the idea is they couldn't have meant that because they didn't prohibit that at the time, right?
Right. Exactly. But there's another version that says, well, you have to, what you're trying to interpret is the underlying concept of, in this context, cruel and unusual punishment or equality. And that concept is what you're after, and it exists one way or another, no matter what. When they enacted the Equal Protection Clause, it says no state shall deny to any person the equal protection of the laws. What they had in mind, what they did, was to enact the idea of equality. Now, they might have misunderstood what equality actually required. And so they may have thought that segregated schools were consistent with equality. But we know they were wrong, and we're following what they enacted. Okay. Now, that's a move you can make with respect to essentially anything in the Constitution. And so it licenses you to do what Justice Scalia disparaged as enforcing your personal predilections.
As an outsider, again, someone who has not been to law school, who has not been a Supreme Court justice, I was struck by, or not yet, maybe we can get to that.
Right. We can talk about that.
Ryan, as Professor Tushnet says, it's ideal to not have been a judge. So,
Yeah. You have a good line in here. You say, towards the beginning of the book, you're talking about kind of, the failures of theories. And you say, quote, typically we adhere to a theory that generates the results we like, which is to say we reproduce at the level of choosing a theory the very disagreements theory is supposed to overcome. And then there's what I think is the deepest difficulty. The disagreements reproduce themselves within each theory. Even if we were all originalists, for example, we'd find that originalism tells those who like some policy that it's compatible with originalism, and tells those who don't like the policy that it's incompatible with originalism. And I have personally participated in this process, just as a matter of trolling people, that, talking about the Bruin gun control case from recently, which was sort of, purporting to establish that, basically the Constitution doesn't countenance New York's like century-old regulations on handgun ownership, and pointing to the manifold restrictions on firearms that were enacted around the time of the Revolution, and in fact some of them written by James Madison himself, who wrote the Second Amendment. But yeah, it's kind of I think it takes it like a sort of deeper, like an interesting level of analysis to say that like it's not that the theory is wrong, though it is wrong, and it's also hypocritically enforced and complete nonsense when you actually try to do the thing that the originalists say they're doing. But it's also like an inescapable problem. You're never going to be able to get away from some kind of prudential judgment, as it were. And I thought that was a instructive thing to learn about and consider.
So I wanted to just say two things. One is I resist. I don't think I say this anywhere in the book. The giving the label wrong to theories, including originalism. I do say that they don't do what their proponents say they do,
They're
which
flawed, right?
keep them, constrain judges from enforcing their personal preferences. And I do, because I'm academic, I feel like I have to say something like this. I do think academic originalism is more respectable than judicial originalism. Academics are just more careful about what they're doing than judges, and they have more time to do it. I mean, there are institutional reasons for it.
Yeah. No, to be clear, I maybe had sloppy wording there. It's not to say that there is no such thing as trying to go and figure out what the drafters of the Constitution actually thought, which is a thing you can do, and there can be productive work there. It's just that even if everybody agreed on that, you would inevitably run into like differences of interpretation and emphasis and so on and so forth, to where you would just be back to political brass tacks on, whether this is quote unquote correct, or this source or that source. And so, while you can bring in originalist type reasoning to your decisions, you shouldn't pretend. I guess that's the thing I'm trying to drill down on. You shouldn't pretend as though the founding fathers have legitimized my decision, or that I have the secret dictionary of words, the textualism Bible that proves my.
Well, that's the thing. As interesting as and illuminating as academic originalism might be, the way it's appropriated in practice is what's dangerous, because of how it pretends not to be doing what all judging does, right?
Yeah.
Which is to make the kind of prudential decisions that aren't, getting the smelling salts and getting the spirit of Madison, to kind of channel through your pen or something, right?
Yeah. So this is sort of the second thing I wanted to say, and it's in some ways the point of the title of the book, Who Am I to Judge? Which, in case people don't pick up on this, is a line that Pope Francis used. Actually, people criticize him for doing it, but he's actually right about what his role was. His role is not to judge. But the role of judges is to judge, and what judging means here in the opinion where Justice Scalia said what people on the other side are doing is just enforcing their personal predilections. That was his phrase. He attached the term personal predilections to another phrase, reasoned judgment. This was in one of the abortion cases. He said the people who are saying that these restrictions on access to abortion are unconstitutional say they're exercising reasoned judgment. But reasoned judgment is just their personal predilections. Well, I think that there is something like reasoned judgment that lawyers, good lawyers, judges who have the right kind of life experience can actually exercise. Now, I do want to pick up on a point that I think Ryan has emphasized, which is that rhetorically, it may be easier to say, well, we're just doing what the framers want, than to say, well, this is the way a good lawyer thinks about these things, because ordinary people can understand the line about what the framers wanted, but precisely because they don't have the training of lawyers, they can't fully understand. I don't fault them for it, but they can't understand what it means to think through a problem in the way a good lawyer thinks through the problem. When I introduced the notion of judicial craft, I say, look, I can't in this kind of book, which is written for non-specialist readers, I can't really explain in full detail what that is, because you'd have to go to law school.
You'd have to do it.
Socialized into this way of thinking to understand it. And a short book can't do that.
I mean, that's part of your point, I think, if I understand what you write correctly, which is that reasoned judgment is a communal thing done in a certain community and in a certain form of life with certain language, games, and practices and moves, as you put it. Like if we follow the game analogy, there's certain moves that are established as legitimate and that then help everyone in the community kind of recognize whether what you're doing is acceptable or not, and whether in this instance it's properly reasoned. I mean, if you think of law as a kind of language game, the interpretation of law, right, then that makes a lot of sense. It's not just an individual's judgment. It's a kind of adherence to communal practices that an individual participates in, just as an individual could play a game that has kind of certain rules and moves that are established, right? And that is very different than, Scalia or someone saying that they know what Madison would have done in a certain instance.
Yeah. So there's I begin my discussion of this idea of craft with a quotation from a famous and great article, which is called Dennis Martinez, who was a pitcher, and the uses of theory. And it starts with a story in which a sports writer notices that the manager walked out to the mound and when Martinez was having trouble and talked to him, and the sports writer asked Martinez, well, what did your manager say to you? And Martinez said, throw strikes over the plate.
Yeah, that's right.
What else? And then he said, what could he say? And what could I say? Of course, that's what I was trying to do. There's no theory there. It's just the practice of trying to get the batter out in this context. And good lawyers like good pitchers, who Martinez was a pretty good pitcher, not great, but pretty good. Good pitchers know, sort of, they have muscle memory that tells them what to do. They couldn't articulate exactly why it is they did what they did. They couldn't have a theory of it, but they do it pretty well.
And if we were to study how to throw a great pitch, apart from actually practicing it, if we we're going to write about it, we might do what you did, which is to say you look at the great pitchers and try to notice what they do and then start there rather than start with the abstract. And so you in your book, maybe you could walk us through a little bit how you went through discerning who the great examples and the exemplars of being a good judge were, and your approach to kind of identifying what they did that you point out constitutes good judicial craft, right?
Yeah. So I start the book with an examination of great justices, and I didn't want to come up with my own list of justices because that would be rightly criticized for being too subjective. So I looked around, and it turns out there are lots of opinion surveys of experts that generate lists of the great judges. And I found one from 2006 where a whole bunch of experts were asked, what's your list of great judges? And they weren't told, and by greatness, I mean thus and so. So you decide what's great and then come up with your own list. And then the surveyor compiled the list. And I looked at the list, and it made intuitive sense to me. So I said, okay, so here's a list of 10 great justices, maybe one or two shouldn't be on the list, maybe one or two others could be added, but it's in the ballpark. And then I asked myself, well, what is it? Is there something that we can find out that unifies them other than their greatness? There's something that might help explain their greatness. And when I looked at their biographies, it seemed to me that on the whole, this is not 100%, but on the whole, their life experiences were what I call wide. They were men. These were all men at the time, men of wide experience, and mostly men of intellectual curiosity. The wide experience was they had been politicians, they had campaigned for office, they had been involved in serious military combat where they'd been brought into contact with a whole lot of people not like themselves. But this sort of wide experience, there's really only one judge on this list who was more or less a hermit. And didn't have that wide experience. And the other was intellectual curiosity. They actually wanted to find out things about the world, mostly about the legal world, but to some extent about the world more generally. Louis Brandeis, who was a public interest lawyer before he was appointed to the court, just read enormous amounts of sociology and economics. Benjamin Cardozo, the hermit, actually read an enormous amount in psychology. Oliver Wendell Holmes, whose character was shaped by the wartime experience, read everything except economics and sociology. They just, wanted to know stuff. And that's sort of interesting, I think.
And you find that quite different to the court in recent years or decades, even, right? That's not been the tendency, especially the part of not getting someone who's served as a judge for a long time. And
right. So the one thing I'd gone into this project thinking that what I was going to find out was that actually substantial experience as a high governmental official, whether elected or appointed, was going to be characteristic. That turned out to be weaker than I thought. Some of it, but it turns out that my intuition about these public official positions was better described as the wide experience issue. But what they were just judges. Only two on the list were people whose basically only prior experience had been in judges, and one of them, Holmes, had this military experience that just permanently shaped the way he thought about the world. And if you look at the current court, actually at the moment, what was their major life experience before this? Well, basically, this gets a little complicated, but all but Justice Kagan were immediately before their appointment judges on federal courts of appeals. None of them, as one of my friends puts it, had ever asked an ordinary citizen to vote for him or her. And mostly, less exclusively, but mostly before they were judges on federal courts of appeals, they were high-powered lawyers in appellate practice. Justice Jackson was a public defender. Justice Kagan was a dean of a law school, but I'm not sure that counts as broad experience. Yeah. Justice Barrett, I think, was a law professor, but has, I think, an interesting life history that, for me, sort of puts her in the broad experience category. I think other people would disagree with that, but so that leaves sort of six of them who were just, appellate lawyers. Not to disparage appellate lawyers, but doesn't bring you into contact with a wide range of human experience.
Right. Until recently, I think all of the court had gone to either Harvard or Yale Law School and even shared the same prep school for a lot of them. Right?
2 out of 9. Yeah. Kavanaugh, and who's the other one? Anyway, that's a pretty high percentage. There are a lot of high schools in the country. It's funny, because I've often thought cynically, looking at, frankly, the corruption of the Supreme Court, that I could be a Supreme Court justice. Like, it doesn't seem that hard. You just hire some law clerks from whoever,
we should get to that, actually.
Your buddy. Your buddies. But to finish my point, though, like, you just get your law clerks to write your opinion for you. You're on the golf course by 3. You just say, here's my political result that I want. And you just reverse engineer, find some citations to whatever, who gives a crap. We're ruling by decree. And you're on the golf course by 3. That sounds easy. But what you're saying is that actually being a journalist and a Peace Corps volunteer and being like wholly ignorant of the law, actually, maybe that's a good thing. And so maybe I should be a Supreme Court justice.
Right. So I'd qualify that a bit by saying I wouldn't. What I would want you to say is, and I'll say a little bit about not being a lawyer in a moment, but I would want you to say not, here's what my political priors tell me I ought to do in this case, but I've lived a life of the sort that you've just described. And here's what seems like the right result in this problem. That maybe often will correlate with your political views, but, in interpreting the securities laws, you're not going to have strong priors about that, given your experience. If you're a high-powered appellate, litigator, your priors will give you some views about that. But I would say, that background experience is actually interesting as long as you bring it to bear on exercising good judgment with respect to the problem at hand. Now, I mentioned the securities laws because, maybe a third to a half of what the court does involves pretty technical stuff. And although I have a colleague who said, well, maybe we should appoint some non-lawyers to the court because they know other technical stuff. I think a non-lawyer would have a problem with the technicality of not much, but a good chunk of what the court does.
To be fair, the justices have a problem with technology and understanding it. So,
right.
There's that corollary.
And I do. This comes back to the stuff about patent law. In every specialized area of law, you can talk to people who specialize in patent law and tax law and pension law, and probably
environmental.
Probably. Yeah, they dread the court taking up the cases, not because they fear that the judges will bring their political predispositions to bear on them, but because they know that the justices just don't understand the field in which this particular issue arises.
I forget the specifics, but I think Gorsuch made like a fundamental error about chemistry in a recent opinion. I forget what the details of that were, but that had some bearing on his argument. But talk about the clerks, if I may. You probably look. Ryan's a chemistry major; he'll figure it out. But if I may, that we didn't mention at the beginning, you were a clerk for one of the greats, right? Justice Thurgood Marshall, and you write a lot about your speculations based on your experience and also your understanding of contemporary court processes, how opinions are probably made and how the clerks are involved. And so part of what I'm curious about is once you talk about that a little bit, how your judgment of what qualities are important in a good justice or judge and what good judicial crafting requires, how important that is when it seems like it's the clerks that are doing all of that or a lot of that for the most part.
Yeah, so I want to say a couple of things about sort of my knowledge base. So I clerked for Justice Marshall. It's 50 years ago. It's a long time ago. I've done a lot of research in the papers of the Supreme Court justices in from the 1930s to roughly 1990. And there's sort of a clerk gossip network that I pick up on.
Right.
And so. Okay, so that's the knowledge base. It's better for going back from, say, 2010, before 2010 than it is for now. But there are patterns that you can see. And I'll do it this way. Take a justice who's been on the court for 10 years. Things are different in the justice's early years. But after 10 years, the judge, a good judge will say, look, I have these now 4 really smart people who work for me, who could craft an argument to support an outcome. It would be crazy for me in the early years. What they do is, it would be crazy for me just to say, okay, you write up the facts of the case and I'll write up the legal analysis. That's lunatic. It's inefficient. It's just bad management of an office. You got these very talented people. You might as well use their talents. Not that they will do better than you than writing an opinion than you would. Maybe they would, maybe they wouldn't. But overall, you run the office to exploit their talents.
Yeah, it's good capitalist logic. Of course, right. You're above them. You exploit. Let them do the work. Yeah.
Right. But what you do is tell them where to come out. My experience, this is the good judge. My experience and judgment lead me to think that the correct outcome here is that the plaintiff should prevail. We've got briefs and they've laid out the arguments for the plaintiff and the defendant. I've looked at them. I haven't worked through them all in detail, but it seems to me that the right result is for the plaintiff to prevail. Now you law clerks go and write up the most powerful defense of that position that you can. That seems to me, A, fine. You get good work done. And B, exploits the different talents that people have. What I say about my experience with Justice Marshall is that I was way too young to appreciate the experience. I'd been out of law school for a couple of years. You're dealing with young people who don't have much experience and therefore may not have very good judgment on these kinds of questions. But the justices have been out in the world for a long time. Again, the ones who are really good at the job, and they can make good decisions without having the full rationale worked out in their heads before they say this is the right outcome. At one point in his confirmation hearing, Justice Thomas said he would approach the case as if he were stripped down like a runner. That is, he wouldn't have any presuppositions. He'd look at the materials and he'd work through what the right outcome is. I think actually many nominees think that that's what they're going to do. And for the first couple of years, that is what they try to do. And then they figure out that's not the way to do the job. And I'm sure Justice Thomas doesn't do that anymore. He relies on his law clerks, which he should. I'm not faulting him. Justice Kagan, who relies on her law clerks.
What's funny to me is that there's an Ouroboros here, because you say that to get the job, often law clerks will try to imitate the voice of the justice in how the justice writes, because they study the opinions before the interview. But then it occurs to me, if the justices are never actually doing the writing, that they're studying the voice of the collective clerks that preceded them, right?
Yeah. So there is something to that, but it's also the case that justices do insert distinctive things that you can almost, that if you're a careful student of them, right, you can figure out what's there. Because, for example, Scalia was a true asshole, and so his barbs were really his. He was like a true jerk who liked to insult people, and that was really authentically him. And Justice Ginsburg liked to use the word path marking rather than path breaking or something like that.
Right.
Now you learn that that's what she does, and you stick it in, and it turns out that she doesn't think you've put it in the right place. Okay, so they will do, they call it heavy editing. I'm, skeptical about how heavy it is, but there is a distinct, they do end up not all sounding, bland and uniform. Each one really does end up having a distinctive voice.
I think I mentioned it in a couple of episodes back in our show that I've been reading Ian Toll's book, his series on the Pacific War, and the last one's called Twilight of the Gods, but it goes into some detail about the Admiral Raymond J. Spruance, who was probably the best naval commander of World War II. And, as Toll gets into in the book, he was very lazy. He delegated absolutely everything he possibly could. He was a fanatic about exercise, and he would just walk in circles around the carrier deck of the ship he was on for like 3-4 hours a day. And if he could avoid work, he would do it. But that left him fresh and collected to do the very most important thing he was, supposed to do, which was just like decide how the battle was going to unfold. And he did, he just like kept himself fresh and right there. And he knew that like, this is my job to do the make the most important decisions in the moment. And if that means while we're just like zipping around the Pacific and I'm reading paperback books and walking around, that's fine. And it kind of, illustrates the point you were talking about.
I just add, I don't know the book or anything about Spruance, but I would think that as he walked around the ship, he'd be observing things.
Oh, yeah, of course.
How the sailors, I guess, or however you want to describe them, were doing their jobs and how the physical layout affected the way they could do things. And all that's in his head when he has to decide, what the course of battle is going to look like.
Yeah, no, absolutely. It was just when people would come to him and be like, oh, Admiral, we need a decision on this or that thing. Where do the Oilers go? Where do we send these planes? He's like, you figure that out. This is not, I'm telling you to do that. But something I want to bring up before the end, kind of lingering in the background of your book, you kind of get at it in a few places, but it is the question of like judicial review itself, and whether the judiciary is equipped to, handle the types of questions that you're talking about. And I definitely agree that this idea of judicial craft is definitely well suited to sort of like getting good outcomes for like legal disputes. But, like in a lot of other countries, there more or less isn't judicial review, or it's very rarely applied, that the parliamentary legislature is more or less in control of these things. And so, for example, to enforce things like the civil rights of the citizenry, you set up a bureaucracy that's okay, we got to protect the environment. Instead of passing a law saying that someone can sue if the environment is damaged, you say, okay, the bureaucracy of environmental protection is going to make sure that happens. And, like, frankly, I have argued in the past, in my work at the Prospect that, that's like more or less a better approach. And that, particularly the hyper strong version of judicial review that we've developed in the United States is just like very dysfunctional. And it seems to me that it's kind of behind a lot of the things that you're criticizing, that you have all these theories, which are basically backfilled rationalizations to be able to rule by decree. And it just seems like the temptation to develop something like that when you have the power to strike down acts of Congress by judicial fiat, especially when it's very difficult to pass anything through Congress, but that's kind of a separate issue. That's just kind of the system's going to produce things like that. So, what do you think about, that type of critique?
Okay, so a few things. First of all, I think the best way to understand this book, which I hope people will buy and read, is that it says its argument is if you're going to have the kind of judicial review we have in the United States, this is the way to do it. Judicial craft rather than constitutional theory.
Right. Okay? And the book is helpful in detailing all of what that entails. So that's, yeah.
Right. But it doesn't take a position on whether we should have the kind of judicial review we have. In other work, I think I'm actually reasonably well known for advocating what I call weaker courts. I particularly like the Canadian mechanism of a legislative override, which actually Judge Bork once proposed. But we don't need to get into that. I will do another bit of advertising. My colleague Mike Seidman and I are doing a podcast called Supreme Betrayal, available on the usual platforms,
Nice.
where we're talking about whether we should have the kind of constitutional review that we have in the
Wonderful.
US. So, and I'm skeptical about whether we should. I think there are ways of reconceiving what we have that would preserve, what's good about it without having the imposition of rule by judicial decree. But I could be wrong about that.
I'm curious if we have time for your opinion. With the system we have, two different books that come to mind. One is the Anti-Oligarchy Constitution, which I don't know if you consider that to be theorizing per se. You definitely write in your book about the idea that, say, currently we expect the courts, like per Marbury, to be the final word and everything. But as Trump is maybe showing, and as the Anti-Oligarchy Constitution shows in a different way, we could view it differently. And maybe Congress has a duty to ensure constitutional protections themselves. And they have an affirmative. And if the public came to understand and pressure them to uphold that responsibility, maybe our politics would be different, because you definitely don't segregate law and politics. You understand that they're necessarily intertwined, right? So I'm curious if you think, is that like unnecessarily theoretical, that kind of approach, or is that a kind of theorizing that could be useful?
No, I think it's very useful. I wrote a couple of admiring things about the book. Its retrieval of the idea of, call it legislative constitutionalism, is really important. Yeah. That legislators, members of Congress, used to think that they had a duty to implement a certain vision of the Constitution. And Forbath and Fishkin, the authors of the book, say we ought to retrieve that practice of legislative constitutionalism, coupling with the specific vision of the anti-oligarchy Constitution. The sort of glitch here is there are two things that I need elaboration. One is, MAGA has a vision of legislative constitutionalism. It's just not the anti-oligarchy Constitution. So what do you do about that? And then second, they struggle to figure out what the role of the courts would be in a world where you had legislative constitutionalism.
That's fair.
And I struggle with that too.
Yeah. To the former question, I think you defeat them politically, which you have to do anyway, because you can't escape the politics. Right. Wonderful. Thank you, Professor.
Yeah. That's a pretty good place to stop, I think. Professor Mark Tushnet. The book is called Who Am I to Judge? Judicial Craft versus Constitutional Theory. We'll link to that in the description, as well as your podcasts, which I did not know about, Supreme Betrayal, and the World War II book I mentioned before. Listeners have been asking that I link the books that I talk about in the show notes. And, because I'm now a father, I have to read naval history. That's in the law. That's in the Constitution. But thanks again for coming on, Professor.
Sure. Thanks for having me.
Thanks for listening, everybody. We'll see you in the next episode.